R-1522, the record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Let's talk about the tender introductory instructions for phase 2. And I'm looking at the defense's tender introductory instructions for phase 2, and there are two of them, numbers 67 and 68. And some of these issues we've already talked about. I'm going to be consistent with what I said before, but I think given that I haven't yet drafted one, my inclination is to draft something consistent with the introductory remarks that we talked about earlier, the introductory remarks at the beginning of the sentencing hearing, at least as they relate to phase 2. Is there anything in here, Ms. Nelson, that you want to highlight for me that perhaps is not included in those introductory remarks? I quickly read it through during the lunch break, and the first paragraph is, I think, some of the same information that's included in the introductory remarks. And I'm probably going to stick with the language that I said that I'm going to use in the introductory remarks to be consistent. The second paragraph, I'm telling them the same thing. The third paragraph in your tendered instruction again is similar to those remarks. I may add that a mitigating factor is not a justification or excuse for the crime. I think that's an appropriate statement of the law. So I may add that. That's not in my remarks, my opening remarks.
If I don't recall this last part, the second to last sentence in that paragraph being in the opening remarks, mitigation can include facts or circumstances about this case or the crime, but mitigation does not need to have any link or connection to the crimes for which Mr. Holmes has been convicted. I think that concept is important to include.
Do the people have a position on that statement, Mr. Orman?
Thank you, Your Honor.
Yes.
Your Honor, I'm okay with it, although my position is that the defendant should be referred to as the defendant in these instructions.
Say that again. You're okay with it, but I didn't get the last part.
My position is that the defendant should be referred to as the defendant in the instructions.
I got you.
My position is that Mr. Holmes should be referred to as Mr. Holmes in the instructions.
All right. I know what both of your position is, and I've ruled on that. Okay. Let's talk about the last sentence. Mitigation is not limited to evidence presented by the defense, but can come from any source. I'll do something similar to what I'm going to do in the introductory remarks in that regard, okay?
Yes, Your Honor, and we do maintain that that is a correct statement of the law and would ask that it be given. It is our position that mitigation can come from any source, even if it doesn't come directly from the evidence. It can be based on a juror's own individual sense of mercy and their own personal morality.
And I disagree. We've had this discussion, and I don't think that's how it works. I think it has to have some basis in the evidence and or information presented in the courtroom. It can't just be independent. You can't have a juror say, the evidence and the information presented in the courtroom didn't do much for me in terms of mitigation, and I think that there is a ton of aggravation, and the aggravation is a lot heavier, and I think that if I had to decide it based on the evidence and the information in the courtroom, my reasoned moral judgment would be to vote for a death sentence. However, based on my own personal beliefs, which I brought into the proceedings with me before I heard any evidence or anything about the case, tell me that I should vote differently, so I'm going to vote differently. I don't think that that's how it works. And I think that's what individual voir dire was all about. So in terms of the next paragraph, again, I have that in my introductory remarks. The next paragraph talks about what happens during deliberations, and I'm going to do something similar to what I'm planning to say in my introductory remarks, which we've talked about, so I'll be consistent with that.
If I may, Your Honor,
Yes.
just on that paragraph.
Yes?
Two important concepts that we think should be included is, number one, if there is any evidence of any mitigating factor in a juror's opinion, that juror must consider the mitigating factor. It's just important to emphasize again that that concept conveys that there is not a burden of proof with respect to mitigation. And then no juror is required to identify which mitigating factors he or she has found to exist. That's also a concept that's related to the individual moral decision-making that is required of the jury during phase two, and I didn't see that specific concept addressed in the court's introductory instructions. And we think it's appropriate to give a slightly more elaborate instruction at the beginning of phase two when they're actually going to begin hearing about this evidence and thinking more about the decisions they're going to have to make.
I think both concepts are covered in my introductory remarks. They're just covered in different words. But frankly, I'm not sure that I have any problem with these two sentences. Do the people have any objection to these two particular sentences?
Seem to be inviting the jurors not to deliberate. That's the problem I have with it. So,
Well, the first one is if there is any evidence of any mitigating factor in a juror's opinion, that juror must consider the mitigating factor. I think that's true. I think that's saying if a juror thinks this is mitigation, they have to give it consideration.
I thought you were talking about the following two sentences. I apologize, Your Honor.
That was the first one. The next one is no juror is required to identify which mitigating factors he or she has found to exist.
That's anti-deliberation, Your Honor. I understand they're not required to do that in a verdict form, but essentially what that's saying is one of the other jurors say, hey, so what are you talking about? And that juror says, no, I don't need to tell you. I don't want to talk. Well, sure, no one's going to, force them to talk, but this is anti-deliberation language, and the court has already found that the jurors have a duty to deliberate.
And, Your Honor, it is absolutely not anti-deliberation language. In fact, we have language in here talking about the jury deliberating. It has nothing to do with anti-deliberation. It's a true statement. The jurors it's an individual, personal, moral decision about whether another human being lives or dies. And they don't have to articulate the mitigation if they don't want to. It's a correct statement of the law. And we'd ask the court to give it to emphasize that this is different than the type of deliberations they have to engage in during the first part of the trial.
Well, I think what you said in terms of this being an individual personal moral moral determination is a statement of the law, and I think that's reflected in my introductory remarks. I will give it as stated in my introductory remarks because I think that covers it. I'm not sure what other goal this particular sentence accomplishes. If the point is to say, hey, members of the jury, you don't have to agree on which mitigating factors exist or even that mitigating factors exist, I'm telling them that already, and I'm telling them that without any risk of confusion or any risk of conveying a different message. So what was there, was the last sentence also one that you wanted to talk about, Ms. Nelson, the last sentence in that paragraph, or no?
To be honest, I'd have to look back at the introductory instructions to see how much it differs, but I think that this concept is covered in the court's instructions.
I think it is as well. All right, what about the next paragraph, Ms. Nelson? Anything that you think that you want to point out?
I mean, obviously I'd like an opportunity to make a record when I get the court's final proposed instruction, but just from a quick glance, I think that most of these concepts are concepts that the court plans on addressing as well.
Yes. And I'll give you that opportunity, obviously. What we might want to do is meet tomorrow again, just so that we don't waste any time on Wednesday, since Wednesday we're going to be on a tight schedule. So the next paragraph is a juror is never required to articulate, explain, or justify the weight that the juror assigns to any aggravating or mitigating factors. Each juror may emphasize one factor more than another, giving each factor as little or as much weight as the juror deems appropriate. A single mitigating factor may outweigh all proven aggravating factors. Each juror may determine what weight to give any mitigating factor, but when a juror has determined that a mitigating factor exists, the juror may not give it no weight by excluding it from his or her deliberations or refusing to give it meaningful consideration and effect. Some of these concepts are covered, probably not all of them. Ms. Nelson?
Yes, and I think that first sentence goes along with what my previous argument was about no juror is required to identify what mitigating factors he or she has found to exist. Again, it's not anti-deliberation language. It's just distinguishing for the jury how this decision-making process is different for them than the decision-making that they were asked to do in the first trial. And so that's our justification and our request based on the Eighth Amendment, the heightened reliability required in a capital proceeding, as well as Colorado Constitution Article 2, Section 20, and Mr. Holmes' state and federal rights to due process and a fair and reliable sentencing proceeding. With respect to the last sentence, well, I should say the third sentence, a single mitigating factor may outweigh all proven aggravating factors. If our record on this would be the same as it was previously, that we would not request the court give this if the court is going to give a similar instruction about aggravation. So we can withdraw.
And I think I would have to. I mean, I can't just give a one-sided instruction, so I won't give it at your request, given that, considering that if for me to include this sentence, I would have to include the converse sentence, and that in that event you don't want me to say anything about this, then I'm just not going to say anything about it. It's either both sentences or neither in that event for me.
I'm sorry, Your Honor.
That's okay. In terms of the first sentence, what I worry about is I think there's a difference between telling the jury, look, this is an individual determination that each of you has to make, and I'm telling them that. I'm telling them that repeatedly, that each step in the deliberations process following phase 2 is an individual determination. Number one, whether there are any mitigating factors. Number two, to then weigh the mitigating factors that exist and the aggravating factors that exist, and to weigh the two. And number three, to decide whether the aggravating factors, the mitigating factors outweigh the aggravating factors. So I'm telling them, look, you have to do these things individually, but ultimately I'm also telling them that they have a duty to deliberate. And if I say all that and then say, oh, and by the way, you don't have to explain, articulate, or justify, so one of these things that you're doing, then is there a risk that a juror is going to take that to mean, well, then I don't have to deliberate? Because when we're talking about this in the jury room during deliberations and somebody wants to chat about why, for me, the mitigating factors weigh more than the aggravating factors, I can simply say, I don't have to talk about it. The instructions from the court says I don't have to explain it to you. So then that would mean the jury is inferring from the court's instructions that they don't have to deliberate. That's part of deliberation. And so to me, it makes more sense to just say to them, without risking confusion, to just say, this is an individual determination that you have to make at each point of the process, and then you deliberate. And that's what I'm telling them through the introductory instructions. Ms. Nelson, you were going to say something else, I think, about the one sentence related to a single mitigating factor may outweigh all proven aggravating factors. Is that right?
I understand the court's ruling, but I wanted to add that it doesn't have to be even or equal. Mr. Holmes is the person in this proceeding that has the constitutional rights, and so our position is that it doesn't have to be that the prosecution gets equal, equivalent language about an aggravating factor. There's a presumption that Mr. Holmes should not be put to death. The default sentence is life in prison, and so we think it's appropriate to give that sentence in the instruction without a companion sentence stating the opposite. But I just wanted to make that record, but I understand the court's ruling on that.
Yeah, and I disagree with you that because of what you said, then I can give the jury just a one-sided instruction. I can't do that. You're right that Mr. Holmes has constitutional rights, but I have to make sure that this is a fair trial, and I have to make sure that the jury gets the law in an impartial way. I can't just tell the jury, here's the law, and I'm only going to talk about things that are favorable to a life sentence. I can't do that. So that doesn't mean that anyone is interfering with Mr. Holmes's constitutional rights. That just means that I have to give the jury the law in an impartial manner. So what's next?
And then just on the last sentence of that paragraph, we think that that's an important concept, that a juror may not give it no weight by excluding it from his or her deliberations or refusing to give it meaningful consideration and effect. That's one of the central holdings of a number of United States Supreme Court cases, including the Penry line of cases in particular, as well as the Mills v. Maryland and McCoy versus North Carolina line of cases. And this was an issue that came up sometimes in voir dire in terms of I know that we objected to it, and I think the court actually sustained our objections to the prosecution telling jurors that they could give it any weight they wanted to, including no weight. So I would ask that the court actually give this specific, include this specific sentence in its instructions to make sure that the jury understands that once they've found that mitigating factor, they have to give it some consideration.
I think the objection in voir dire was a little different, and the reason why it was unclear, I think, is that the lawyers would talk in terms of, hey, you have to give any mitigation presented full effect and consideration. You cannot give it no weight. And then I think the prosecution would say something like, hey, it's up to you to decide what weight to give each mitigating factor, and you can decide to give it no weight. And I think to avoid any confusion, I said the prosecution could not tell the jury that he was entitled to give no weight to a mitigating factor. But what I was implying in my ruling is that if a juror is trying to decide what weight to give to a mitigating factor, the juror has already determined that the mitigating factor exists. Obviously, a juror is free to say, I don't think this mitigating factor exists, and thereby give it no weight, because the juror is finding this is not mitigation. That's the clarification I think that's required. This last sentence makes that clear. This last sentence is different than I think what counsel were saying during individual voir dire. As I said, I ruled in favor of the defense in individual voir dire just because I thought this was too detailed to try to explain to the jury, and I thought that it was important to avoid any confusion. But I think this is, I believe this is a correct statement of the law, and that is that once a juror determines that there is a mitigating factor, then that juror may not decide to give it no weight or to disregard it. That juror has to give it full consideration and effect. Now, it's up to the juror to decide whether to give it little weight, moderate weight, or heavy weight. That's up to each juror. But once the juror has decided this is mitigation, the juror is required by law to give it full consideration and effect. Mr. Orman, do the people have a different view of the law on this last sentence?
No. No, Your Honor. The one thing I would note, though, is at least on this instruction, and we're going back to the top paragraph of this page, so I don't remember exactly what the court was going to do on it. Second full sentence on this page seems to incorporate the same concept. I agree that the concept should be given to the jury, but I don't think it needs to be. I'm not using the microphone on that. I don't know if you want me to repeat what I just said, Your Honor.
That's okay. Mr. Orman is just saying that this is, he doesn't have any objection to this last sentence in this paragraph, but that it is repetitive of a sentence in the first incomplete paragraph on this page, and it appears that it is. So I will figure out a way to not make it repetitive. Okay, what else, Ms. Nelson?
Bottom of page 3, if one or more jurors are not convinced, the sentencing trial only moves on to phase 3 if every juror is individually convinced beyond a reasonable doubt that the mitigating factors do not outweigh the proven aggravating factors. Again, that's the precise language from Tennyson, and we struggled with rephrasing that, and any we played around with it and couldn't come up with a way to rephrase it that we thought was compliant with Tennyson. So my specific request would be to give that language exactly as it is here. And then if one or more jurors are not convinced, the sentencing hearing stops and Mr. Holmes will be sentenced to life imprisonment without the possibility of parole. Again, I think the court granted my request to change part of the introductory remarks in that regard to be consistent with this language,
Right.
something similar. And so I just wanted to point that out.
I think that's right.
And again, the law is fully satisfied with such a result. We continue to maintain that that language is required by the state and federal constitutions.
And I continue to rule that I don't know what that means, and I don't think that it adds a whole lot. I think there is a risk of confusion, and I don't think it's necessary because I don't think it adds a whole lot.
And then just the last paragraph, I think, is it's pretty standard language. We would ask the court to include it, that they should reserve judgment and decline to form any opinion until they've heard the evidence presented.
And I think what I ruled was that I would include that in my admonishment, so I don't know that, I don't think it's necessary in the instruction. Okay, let's go to actually, do the people have anything that they want to talk about with respect to this instruction?
Your Honor, I think all the points that I would want to make have been covered.
Okay, great. There's then tender instruction number 68, which reads as follows. The defendant is never under an obligation to present any evidence or information, nor does he have the burden to prove or disprove anything during the sentencing hearing. There is no burden of proof assigned to either party during phase 2. Do the people have a position on this, Mr. Orman?
I don't have a particular objection, looking at it now, and we've probably used this terminology before. I just wonder how many non-attorneys understand what we mean by party. It seems to me maybe it should say there is no burden of proof assigned to either the prosecution or the defendant during phase 2.
Okay. Ms. Nelson, do you have any objection to that?
Prosecution or defense?
Okay. That's what I'll do. All right, anything else? There's a people's standard instruction that they provided today. Let me read it into the record because the people provided it today, so it hasn't been filed. It reads as follows. The court has previously limited the admissibility of certain evidence related to the defendant's mental condition, specifically statements made by the defendant in the course of his court-ordered sanity examinations and information derived from those examinations and the information contained in Exhibit P-TR-341, the notebook. The court has limited your consideration of this evidence to the question of whether the defendant was insane at the time of the commission of the charged offenses. During this phase of the trial, you may also consider these statements in your determination as to the existence or absence of any mitigating factor. Does the defense have a position on this standard instruction?
We object to it as it's written for several reasons, Your Honor. First of all, we would propose that the instruction refer generally to evidence that was admitted at trial on the issues raised by Mr. Holmes' plea of not guilty by reason of insanity, because it's not a excuse me, Mr. Orman, I'm making an argument. You can respond.
I'll stipulate.
Okay, hold
I'm
on.
saying we don't. I agree. That's
Okay,
fine.
one at a time. Okay, so he's agreeing to that. What else?
And then the second objection that we have, well, let me just tell you the way we think it should be phrased. Evidence that was admitted at trial on the issues raised by Mr. Holmes' plea of not guilty by reason of insanity may be considered by you during this phase 2 on the issue of mitigation. And the concern that we have, I know that this proposed instruction tracks the language of the statute in terms of proving the existence or absence of any mitigating factor, but I think it's confusing to give the jury that language because the fact is that the prosecution is not permitted at phase 2 to rebut mitigation that the defense hasn't introduced. And so we would object to the phrasing of that because I also think it's just confusing to the jury in the sense that they may think that a particular piece of evidence or a statement is in and of itself a mitigator or not a mitigator or something like that. And so I think it's accurate to say may be considered by you during phase 2 on the issue of mitigation, and then address the statements again separately in phase 3. So that would be our request.
Do the people have a position on that, Mr. Orman?
Your Honor, I mean, this is what the statute says, is how this evidence can be used. And if it's used to, I guess counsel is right that we cannot rebut a mitigating factor that is not placed before the jury. I don't know what mitigating evidence the defense will place before the jury, either through asking for an instruction on a mitigating factor without presenting evidence on it, or presenting the evidence. I think in either circumstance, the jury can consider it as to the existence or absence of a mitigating factor. But the legislature has determined that this is the fashion in which this evidence can be considered in this phase of the trial as to their determination of the existence or absence of any mitigating factor. And I think it needs to be limited to that, because the way that counsel is suggesting it, it would be a much broader theory of admissibility, which is not what is authorized.
Ms. Nelson and Mr. Orman, what if I said something like the existence of any mitigating factor or the absence of any mitigating factor presented by the defense?
I mean, I think it would be more accurate to say, instead of the absence or of a mitigating factor presented by the defense, to rebut a mitigating factor presented by the defense. I mean, if the court's rejecting our initial proposal.
Your Honor, the reason I think that it should be this way is there's a lot of evidence that was presented during the trial in chief, the guilt phase of the trial, that I think that defense might want to argue goes towards mitigation. Evidence that was presented by the people through Dr. Metzner, perhaps, or Dr. Reed, perhaps, or some other Gargidata, or something along those lines, that the defense might say is mitigation. It was not presented by the defense and was not even presented during this phase of the proceedings. It was presented earlier. It's still something the jury can consider as mitigation if they believe it constitutes mitigation. So I think that the language found in the statute is clear and demonstrates to the jury that they can consider this as to the existence or absence of a mitigating factor. Let's just say, Your Honor, that the defendant also wanted to say, okay, we want the jury, the court to instruct the jury on all the statutory mitigating factors that are available. And we don't have to present evidence on that, because all the evidence that they need has already been considered, even presented, even evidence presented by the prosecution. Well, I think then, even if no additional evidence is presented, the jury can consider this evidence as to whether those mitigating factors exist or do not exist. So I think that modifying this language is asking for trouble, and the language as from the statute is correct, and that's what we should be using.
All right, I'll draft something and give it to you tomorrow. Okay, I'll tell you one thing that I don't like about this instruction, Mr. Orman, is that it tries to specify the language or the evidence that was admitted for the limited purpose of considering the issues raised by the not guilty by reason of insanity plea. And I just worry because I'm not sure that the evidence that's listed in here is complete in terms of the evidence that was so limited. I don't think it was just a notebook and the testimony of the experts. And I think that there was other evidence that went beyond that. And so my preference would be to leave it more general as opposed to specifying the evidence that was admitted for that limited purpose.
I agree with Your Honor. The reason I drafted it this way is because this is what the statute says is how this evidence can be used in the sentencing phase. It talks about the types of evidence that can be used. Now, if the defendant wants that expanded to other types of evidence that were for a limited purpose, in the first phase of the trial, in the guilt phase, I don't have an objection to that. But the reason I drafted it this way is I didn't know that that would be their position. So I tried to track the language of the statute that is at issue. I agree, Your Honor. For instance, the statements to the experts that were called by the defendant, I don't know are necessarily covered by this statute. I imagine the defendant would want them to be used for mitigation. I don't have an objection to that. So I don't have an objection to broadening the applicability of the court reducing the limitation on the admissibility of this evidence. But I didn't think that that could be done unless the defendant wanted it.
The statute says that, and it is 16-8-107, subsection 1.5A and B, and I think this is the citation that Ms. Nelson had inadvertently included after the elemental instruction related to the final phase 1 instructions. But subsection 1 says that the instruction applies with respect to, or not subsection 1, but the first part of those two subsections says that the instruction applies with respect to evidence acquired directly or indirectly for the first time from a communication derived from the defendant's mental processes during the course of a court order examination pursuant to 16-8-106, which governs the examination and report the court must order when a defendant pleads not guilty by reason of insanity. That means that it would apply with respect to any evidence acquired directly or indirectly for the first time from any communications by the defendant to Drs. Reed and Metzner. The second part says that it applies to evidence acquired pursuant to section 16-8-103.6, subsection 2A, which governs the waiver of any claim of confidentiality or privilege as to communications made by the defendant to a physician or psychologist in the course of an examination or treatment for such mental condition. So wouldn't it also apply to Dr. Fenton's notes and Dr. Fenton's testimony?
Yes, Your Honor. And I had thought that that would have been covered by the way that this was drafted because it talks about information derived from those examinations. At least I had meant it to incorporate that. So I agree with that. But there's some stuff that is not necessarily incorporated within. I think the notebook also is covered by that, by the waiver. But I guess what I'm talking about is, let's say testimony from Dr. Gurr about statements that she says the defendant made to her that were not derived from the waiver necessarily because we didn't even maybe find out about them until her testimony here, or similar with Dr. Woodcock or Dr. Hanlon. I don't know that that's covered by this statute, which is the reason I drafted it this way. If the defendant wants it to be covered, I don't object to that. But I think that actually does go a little bit beyond the way the statute says that information can be used. But I think the defendant probably wants that, and I understand why. So I don't object to broadening it in that fashion.
All right, Ms. Nelson?
Your Honor, the reason we proposed a similar instruction about the prohibition of the jury's consideration of this evidence as aggravation in our tendered instructions in Phase 1 is because the court gave the limiting instruction to the jury on a whole host of different witnesses' testimony and pieces of evidence. So the court's exactly right. Fenton, Feinstein, Woodcock, Gurr, the notebook, all different kinds of things. And so that's why we think that hold on a moment.
Do you have a tendered instruction on this particular point, Ms. Nelson, similar to what the people submitted earlier today?
I was going to tender it when we submit our final instructions for Phase 2. But we crafted an instruction that the court incorporated referring to this evidence and prohibiting the jury's consideration of this evidence at the first phase in support of aggravation. And so my point was just that...
but I think I probably should say something at the beginning of Phase 2 as well. Because then it changes. I mean, it's easy in Phase 1 because you just say, hey, Remember all that evidence I told you about that you can consider only for purposes of the issues raised by the not guilty by reason of insanity plea? You can't consider any of them at this phase. That's easy, right? You can't consider any of that evidence at this phase one. In phase two is more complicated because they can consider it, but for a different limited purpose. And so I probably should say something about that at the beginning of phase two.
And we're fine with that. Our proposal would be evidence that was admitted at trial on the issues raised by Mr. Holmes's plea of not guilty by reason of insanity.
Hold on. Okay?
May be considered by you during phase two on the issue of mitigation.
Okay. All right, I'll take a look at it and then I'll draft something overnight. Okay, what I propose is that you let me do some work and try to get some of these changes done, and that we meet again tomorrow so that I can give you the finalized introductory instructions, phase one final instructions, and phase two introductory instructions. And then we can have any other discussion that we need to have about those instructions at that time, and then really finalize them after that. And then we can also do the Curtis advisement tomorrow and chat about any allocution advisement at that time as well, if you wish.
I have a couple of questions for the court, if that's
Yes.
okay. I don't object to the proceeding the court just suggested, and Ms. Tish McGuire has an issue. Regarding the closing arguments for the three phases, I know that the court had indicated, at least for the second and third phase, if we get there, I don't remember if it applied to the first phase, that there would be four closings: a closing, opposing parties closing, a rebuttal closing, and a rebuttal closing. And I have a few questions about that. One
Well,
is...
let me interject for just a moment. In terms of phase one, I don't know that I would call them closing arguments because they're just arguments, right? There's not going to be any evidence. And we can talk about whether I need to set time limitations on those. I can't imagine that they're going to take more than 10 minutes per side, but if you want more time, more than 10 minutes, we can, we can talk about that. But my recollection, and I haven't gone back and looked at my order recently, my recollection is that in phase two, what I had said is that in terms of closing arguments, the defense would go first and the prosecution would go next. I don't remember that I said that there would be rebuttal closings at that phase. In phase three, I said the prosecution would go first, the defense would go next, but then I would give both sides a chance for rebuttal, with the prosecution going first in their rebuttal and the defense going last, and that I would give the defense, Mr. Holmes, the last word. That's what I remember from my order on this point. Do you remember something differently?
I think that is correct.
Okay.
I think I'm going to need more than 10 minutes on Wednesday.
How long? Half hour?
I think I can do it in a half hour. I'd request 40 minutes, but I think I'll do it quicker than that, just in case. I haven't timed it out.
Okay. Is the defense okay with 40-minute limits for phase one arguments?
No objection to that.
Okay, great. All right, 40 minutes per side. And that's just the prosecution. Actually, in phase one, the prosecution goes first, the defense goes next if the defense wants to go next. If the defense makes a closing argument, I'll give the prosecution a rebuttal because you have the burden of proof. Neither side gets a rebuttal in phase two because neither side has a burden of proof. I am giving both sides a rebuttal in phase three because it's the last phase and it's right before, if we get to that point, it's right before the jury will make the decision in terms of what sentence to impose, okay?
Do you have any idea how much time you might want to give us in phase two and phase three if we get there?
I haven't decided yet. I'll probably have to wait until I see what evidence comes in and then go from there.
And regarding the rebuttal, I just want to make sure that we all understand this so neither side gets into a situation where we're not certain of this. When you say rebuttal, that actually means rebuttal to the previous argument. It's not just you can talk about anything you want that wasn't raised in the previous argument. And then if a side waived that argument, there'd be nothing to rebut. Is that correct?
That's exactly right. Rebuttal means rebuttal. It's not two closing arguments. It's a closing argument and a rebuttal closing argument. So if the prosecution goes first and the defense decides that they don't need or they don't want closing argument, you don't get a rebuttal. And if you go first, the defense goes next, and you don't do a rebuttal, then they don't get a rebuttal either. So, all right. Is the defense, go ahead, Mr. Orman, did you have something else?
McGuire has something else.
Oh, yeah, that's right. I'm sorry. Ms. Stitch McGuire?
Thank you, Your Honor. Your Honor, I wanted to make a brief motion in limine for the court. The defense this weekend gave us their good faith witness list for the penalty stage. And one of the witnesses that they told us about was a witness I'll call JJ for purposes of protecting her anonymity. This witness is someone who is the director of adult discipleship at a church that the defendant's mother and the defendant's sister attend. But in the two reports that were provided by the defense, this witness indicates that she's never met the defendant and didn't even know that the defendant's parents had a son, and that she had been on staff for 10 years and she had never seen the defendant attend a class at the church. So I don't understand how any of this evidence could relate to the circumstances of the crime, nor the character, background, or history of the defendant, and think that it's all completely irrelevant to the mitigation phase of this case, and would ask that that witness's testimony be excluded. And I have copies of those two reports, Your Honor, if the court would like to see them as an offer of proof of what the people were provided in discovery.
All right, who wants to address the motion? Ms. Higgs.
Yes, thank you, Your Honor. Your Honor, we continue to maintain that information, testimony with regard to especially Mr. Holmes' very close family members are relevant to show his family environment and therefore are relevant to show his character and to his background. I would also note that this witness has had contact with members of the Holmes family, as it indicated in the reports, since July 20th of 2012, and has relevant testimony with regard to some of, particularly Mrs. Holmes' reactions during a church retreat as a result of the impact this has had on her. So we believe that that information is relevant and should be presented to this court. We would cite the court to Mr. Holmes' right to due process under both the United States and Colorado constitutions, under his right to a fair trial, to present a defense, and a right to a fair and reliable sentencing hearings under the relevant provisions of both the United States and Colorado constitutions. And in addition, Your Honor, the prosecution indicated to me just this afternoon that they were going to bring this up. That is my argument at this point. I haven't had considerable time to reflect on it. I believe that's the extent of my argument, but I would like the opportunity to reflect on it. If I have anything additional to add, I would like to be able to do that in the morning.
Okay, that's fine. I'll give you additional time. I can tell you that based on what I just heard, it doesn't sound like this is admissible testimony. She's entitled, witnesses are entitled to talk about the defendant. If we get into the defendant's relatives, parents, we could have all kinds of witnesses talking about not the defendant, but his family members or perhaps other relatives. I don't think that's what mitigation goes to. Mitigation is supposed to go things that are favorable to the defendant himself, his character, his background, his history, or perhaps his crime, but not his mother's character or his mother's history or his mother's background. And in terms of the impact that the crimes may have had on his mother, while no doubt real, I'm not aware of any authority that allows that type of evidence. That sounds to me like impact evidence. And of course, there is victim impact evidence that's allowed. I'm not aware of impact evidence related to a defendant's parent or relative. If you have authority that says otherwise, I would love to see it, but I'm not making a ruling yet because you're asking for more time and I'm giving you more time. But my initial reaction is that it doesn't sound like this is anything that would be relevant or admissible. All right, is there anything else we need to talk about at this time before we adjourn for the day?
What time do you want us tomorrow?
I was thinking maybe 10:30, just to give me time to complete all the work that I need to do, if it's okay with the parties, Ms. Nelson?
So is the court planning on distributing its revised remarks this evening or tomorrow morning?
I'm going to try to do it this evening, but you keep talking to me, and it's 4 o'clock, so I keep trying to get off the bench. I think the first time I said we're about to adjourn was about 15 minutes ago, so I'll do my best to get it to you this evening, but some of it may be tomorrow morning, and that's why I want to give us a little time, maybe 10:30 in the morning or so that in case I don't get everything out to you, you have a chance to review it before you get here. So would 10:30 work for you?
That sounds reasonable, Your Honor.
Okay, why don't we do 10:30? Okay, great. Ms. Higgs.
I'm sorry, Your Honor, I know you're trying to get out of here. We would ask leave of the court to file in writing a motion for a delay in the sentencing proceedings, not at the outset, but in the middle of mitigation. We've had two witnesses, one that has a family member who just went into hospice that we were unaware of, and one that just had a family member that passed away, I think yesterday or today, and is not available within the time frame that we have. We would just like to be able to put that in writing for the court, perhaps tomorrow morning with additional information as we get it. I think a delay would also serve the purpose of us being able to call some of the other witnesses that we had made motions for depositions on, so we would include just the factual information about that in the pleading for the court.
The request to file something in writing is denied, but I'll give you a chance to make an oral request, if you will. I'm not inclined to delay the proceedings. I will work with you. I will be extremely flexible with you to make sure that you can call all your witnesses. Obviously, we did a videotape deposition earlier today at your request, even though, frankly, you could have subpoenaed that witness. Of course, it would have required the witness to miss his vacation or to cancel his vacation plans, but that doesn't mean that you couldn't subpoena him. And if you had subpoenaed him or you had asked me to enforce that subpoena, I would have. And I would have worked with you to get him here, even if it meant in the middle of his vacation. You went in a different direction and asked for a videotape deposition, and I granted that request. But in terms of the other witnesses, my understanding is that we are not going to start with the defense's mitigation case at the earliest on Wednesday. Today is Monday, so we're talking about 2 days from now. And then my plans include going for about a week until the following Wednesday or perhaps the following Thursday. Then that would be July 30th, I think, that Thursday. Then Friday, July 31st is a day that we're planning to take off. Then we have the weekend. Then we have August 3rd, Monday, August 3rd. I'll work with you to let you call these witnesses sometime between now and August 3rd. I mean, I'm not sure why the circumstances that you just outlined would prevent somebody from being able to come here and testify during that time frame. Nothing you said would indicate to me that people would be prevented from coming here at some point during that time frame. And I will be flexible. If we have to work on Friday, July 31st, I'll ask the jury to do that. If we have to start early on a particular day, we'll do that. If we have to stay late on a particular day, we'll do that. If we have to do it during the lunch hour, we'll do that. I'll be flexible as I can be in order to accommodate your witnesses' schedule. So, all right, let's adjourn for the day, and then I'll see everyone tomorrow morning at 10:30. The court will be in recess. Thank you.